folks. We are back on the Reg.A Money Show, and with Miguel, we're going to start to answer a question from one of our listeners, our contender, and we're going to break down some of the costs involved from in the legal field on this, on the Reg.A. So, Miguel, let's get to that. Let's answer his question.
Okay, so this goes out to Neil, Ron, and Neil actually was just kind of wondering what's involved in the legal aspect and the legal services of somebody who is going to be doing an A-1. And guys, and I want you guys to get familiar with this, with this form. The SEC has a lot of different forms. I mean, that's all that the SEC does is they formulate forms. That's not all they do, but one of the big things that they do is that they provide, but no, honestly, what the SEC does is they have a form for all the different types of filings. So, they have an 8K. An 8K is to give information to the public. They have a 10K, which is an annual report of a reporting company. They have a 10Q, which is a quarterly report that public companies have to perform. And then there's a myriad of different forms that people fill out to post with the SEC. Now, your SEC attorney, okay, should be charging you for a few things. Okay, and I think, Ron, last week when we spoke, $5,000 in the low end at $25,000. I think it was in that range, right?
Yeah, that's right.
Yeah,
right.
And you guys have to understand that, we're doing a lot of this. A lot of the companies, when they file Reg.A, they list their legal fees on the last page, okay, of their financial reports. So you can go looking through the different financial reports of these Reg.As that are filed under the EDGAR system, under the Securities and Exchange website, sec.gov. You can go look up these different companies that are doing Reg.As, and you can see exactly what they're paying for in legal fees. But now, here's the point. So you have to have the attorney who's going to file, who's actually going to prepare the A1. And here's the essence of that A1. One, you want what's called an MD&A, Management Discussion and Analysis, MD&A. Management analysis and discussion is very important in the sense of this is how you are going to tell your story. This is your discussion in regards to your business plan. This is the analysis that you've done of how you solve a problem in your industry and how you differentiate yourself from your competitors and in your industry. Now, is this in a complete marketing job? No. This is very factual. There is some marketing. It's peppered. You got to have a little peppering of it, but you can't do we're number one in the industry. You can't. There's certain statements that you want to stay away from, and your counsel will counsel you on those different statements. The other crucial thing that counsel should help with, it's what's called disclosures and risk factors. Risk factors and disclosures, I think, are one of the biggest things that counsel helps you put together. Because according to your industry, okay, and whatever industry you choose to operate in, there are going to be disclosures and risk factors that you have to make your investors or your potential investors aware of. Now, the attorney is going to look for these risk factors. And risk factors and disclosures are going to come from, guess where? Your management's discussion and analysis. Because that is what's going to drive most of these risk factors are templated. That's why when I say to you, you can cut a lot of your legal fees down, is because a lot of this stuff is templated. All right, I want you to understand that. There are certain risk factors that are associated with Reg.As. So they're going to include all of those. Those have already been written and used and reported that they're okay, because you have to understand there are approximately 179, 180 some odd Reg.A Tier 2 pluses filed with the Securities and Exchange Commission. A lot of those have been qualified. And once they're qualified, the attorneys, if they're smart, they go through those to see where the SEC had comments, where the SEC had concerns, and address those on your A1. So now, on your A1, you have your management's discussion and analysis, you have your risk factors, and you have your disclosures, okay? You also have to have your management team's bios, the bios of your management team. Who makes up this team that is going to set the world on fire? You definitely are going to want to have those. You're going to have projections, what the company is going to look like after it gets capitalized. You're also going to have your financial statements. What does the company currently look like? Okay, and then what we're going to do for you guys, because when Ron and I went onto the break, I thought Ron was into something very interesting here. We're also going to break down your financial statements on a later show, what you should be expecting from your PCAOB auditor. Okay, what are some of the things that they're going to do and some of the things they're not going to do. Okay, so now, so those financial statements, they're going to be compiled by somebody else, but somebody's going to have to review them because they all include different notes. Okay, the PCAOB auditor will review the notes, but so will legal counsel. So you have to have some legal counsel looking at those notes to your financials. Now, there essentially is the majority of the work going back and forth from the officers of the company and legal counsel to make sure that the MD&A is discussed, that there is a great history, okay, from inception to the present day of the company, so that way all the investors or potential investors have a really good understanding of the business plan. That's where you bring out a lot of the ideas and you develop some of those ideas in the MD&A. Okay, now, after all this is done, you're going to file this document with the Securities and Exchange Commission on the EDGAR system. We'll break that down and EDGAR filing services on what you should be expecting there on another show. But here's the real essence of legal. Once you file that initial registration, that A1, that initial A1, the SEC looks at it. They take anywhere between 25 to 35 days. You know, we're seeing upwards now of 30 to 45 days, you know, because it's kind of like their season, because, you know, right now everybody's reporting the first quarter year ending. Some people are actually doing their year ending also is due at this time. So there's a lot of reporting going on at the Securities and Exchange Commission, Ron. So what ends up happening is that you're going to see anywhere between, you know, 30 to 45 days depending on when you're filing. Now, they're going to come back, guys, with what's called comments. They're going to make comments, and they're going to put that in a nice letter to you that says, hey, these are our 8 or 9 or 10 or 15 concerns in regard to your A1 filing. And then you're going to have to go with counsel, sit down, and address each one of these and reply. So it's called correspondence. So you're actually going to file this correspondence on the Securities and Exchange Commission's website, their EDGAR website, the site that takes all these reports and manages it for them. Nobody will see your correspondence at the beginning because the corresponding takes 6 months before it ages into their system before you can actually see how people responded to some of the questions. And that way you can see the give and go, you know, what questions the SEC were looking at and then how people responded to those questions. Those are a very interesting read. I always enjoy reading those. If you guys get a chance, you should look those up because it's very interesting on how the SEC works and what they think about and what they look for when they're looking at these types of investment vehicles, okay? So it's always a very interesting read. Now, counsel will help with the comments. There'll be a back and forth with the SEC. Then finally it'll get qualified. Then the last step for counsel will be to write an opinion letter, okay? The opinion letter is counsel's opinion letter to the validity of the stock, okay? If there's any restrictions on the stock, it'll be commented on. If there's restrictions, if there's not restrictions, you know, there may be some forms that some of the officers or some of the insiders, people who are holding, you know, 5% or more will have to disclose that. I mean, there's a few different things there, but your $25,000 and your $55,000, that's what your $25,000 to $55,000 is going to. That's why I say the high end, the low end. You know, guys, I've seen legal bills go all the way to $150,000. If you are a giant company, okay, and you have hundreds of thousands of transactions, you're not going to pay $55,000 for an A-1. It doesn't happen, guys. I'm sorry. If you're a big company, you are going to spend $150,000 because there's a lot more disclosure. There's a lot more history that needs to be covered. But if you're a startup, or maybe you're an inception company, or maybe you've only been in business for, like, say, 3 to 5 years, I think that's a good sweet spot for you to consider to be in. So, Neil, basically what I'm saying to you is there's 3 major components: the A-1, okay, drafting, and all the work that goes into the A-1, the comments that come back from the SEC, the back and forth between the company and the Securities and Exchange Commission, and then the third and final step is the prospectus and the opinion writing by the attorney or the counsel of the company that designates the stock and where those stocks should be. So right there in the essence is the itemized services for legal. And I mean, yes, can we drill down a little bit more and get a little more? Yes. But you know what, guys? That's why I like these questions, because you guys are starting to think about things. You're actually starting to talk to people out there, and you're realizing that Miguel and Ron on the Reg.A Money Show are bringing you some top-notch information. Just like Neil saying, my confidence has been greater because I've been listening to the podcast. Hell yeah, you're going to know what you're talking about, because now you've actually heard some of these terms and some of this terminology being used, and you're not intimidated by that. So, hey, I think we've done our job.
Absolutely. That's a great explanation, Miguel. But I do have one question. What do you say to a company that maybe has one of their founding people, maybe he's a lawyer, he's an attorney, he founded the company with his partner, and now all of a sudden they're thinking about Reg.A, and the guy says, you know what, we don't have to hire a Reg.A attorney. I'm an attorney. I could do the work myself. I mean, what would you say to somebody like that?
So look, aces in their places, Ron. Aces in their places. Look, you don't want any type of attorney doing work when it comes to public securities, or private securities. You want a security attorney. If I'm getting a divorce, I want a divorce attorney. I don't want my SEC attorney handling my divorce, right? And if you have a business, look, I know tons of companies that have in-house counsel. And you know what? If your in-house counsel is telling you, I'll file the A-1, then you should fire your in-house counsel, okay? Because he doesn't have the specialties that are required for different security law. You should definitely have a guy who practices in security law, because security law is a little different than torts and general business practices. I'm not saying that counsel can't be included in that, and it's not saying that you have an advantage, because you do have an advantage. If one of your founders is an attorney, well, then that's great, because the attorney is going to have a level of understanding with the SEC attorney, which is going to help out do a lot of these disclosures and a lot of these risk factors, and a lot of this MD&A is not going to have to be reviewed a couple of times by the SEC attorney. It could be reviewed by the in-house counsel. So, Ron, I would say, man, if you have a founder or you have a large shareholder who's willing to help out, who is an attorney, okay, who already is part of the company, I would definitely engage them and say, look, we're going to be looking at some security attorneys. Would you come to these meetings with us and give us your opinion on what you think would, set this attorney aside from all the guys that we're going to be meeting in the next couple of days? And look, and if you don't have an attorney on your board of directors or you don't have an attorney as part, you can always call Ron and I here at the Reg.A Money Show. We'll be able to help you out with that too. So, I think it's a great thing to have in-house counsel, Ron, but I think that you have to keep their aces in their places, my friend. Aces in their places. The security attorney doesn't have to be with you forever. The security attorney, you could have the security attorney that specializes with A-1 filings work with you, and then you can get an SEC attorney to kind of help you with your filings over a period of time later on in the game. And then eventually maybe your in-house counsel takes care of some of those responsibilities because, hey, he's been working with the SEC attorney for a year or 2 years, and he's picked up